Well, let's do a little mic check here. I'm not sure you guys can hear me or not. Let's see. We can share this somehow. Let's see. Who can we share it with? Oh, you can't share it that way. I see. All right. Manage link, tap the show button, feature. All right. What's this do? Request audience. Let's see. Well, there's a lot of people. Let's just see what happens with this here. That's pretty cool. Okay, now what do you do? I'm not sure what you do after that. Scroll to the bottom and hit accept, or all right, you can hear me. Cool. I did this video on TikTok the other day, and then I got banned for it, of course, because they don't like too much truth being out there. And as you know, Facebook now limits your video exposure to 30 days. So we're going to cover some information here. I've been talking about the court system being a bank for, gosh, I don't know, the better of 15 years, comprehending and understanding what it is and the nature and causes of the action. And so I guess first things first, we'll pull this up here. It appears somebody has caught on to what we've been talking about. It says Quitam criminal charges approved and ordered in U.S. tax court. Remember how I tell you all these lower inferior courts under Article 1, Section 8, Clause 9 are just tax courts? That's what they are. Well, somebody else has managed to figure that out. Todd D., trustee and trust protector. Remember how I always talk to you about trust law, and it's important to always have a trust protector? But it appears that Todd D. here is a trust protector. I think I've seen this gentleman before. He actually pointed out shortly, about a year or two ago, he was pointing out the Money Net Daily Log Transaction Report 120, which is funny because Smoking Baby and myself, we've been talking about that for over 15 years as well. But some other people are starting to catch on to what we're talking about, these trained professionals, and they're starting to recognize that what we're saying is true, correct, accurate, not misleading. They're now moving forward. So a Quitam action, of course, is after you have notified the Attorney General that criminal offenses are afoot. And so naturally, you got to notify the Attorney General of the criminal activity that's afoot and give them an opportunity to bring allegations and charges on behalf of the United States of America, because the Treasury always gets the first bite at the apple. And so what it says here is filed against the clerk of the court, all right, filed against the clerk of the court, the judge, the DA, and the deputy prosecutor. Now, the importance of this is because they're running their own private little fiefdom under a Duns and Bradstreet number, and they're dragging you into a foreign jurisdiction using foreign law. And they're violating the Sixth Amendment as well as the Seventh Amendment, your right to trial by jury. And they're subjecting you to foreign legislation that is not applicable to you absent your consent. So what they're doing is they're getting manufactured consent, because what they're doing is they're hypothecating your credit into existence, and they're getting it advanced from the Treasury, and they're not giving you the proceeds, the profits, the gains from it, and they're holding it in abeyance under a discretionary trust. And so as you start to learn the court system for what it is, they're administering a bankruptcy, which is clearly articulated in Article 1, Section 8 of the Constitution. For those of you that say the Constitution doesn't apply, I've got news for you. There are multiple forms of government afoot at any given time, and they can switch hats anytime they see fit. More importantly, when you put them give them proper notice and notice of liability, you can put them in the position where they bear a duty to respond, or they can be sued not only in their personal capacity, but their professional capacity, their criminal liability, as well as their professional liability. So they have unlimited commercial, civil, personal, and professional liability. Now, on the professional aspect of it, you might have to pull a Monell lawsuit, which is pretty simple, pretty straightforward, under the auspice that the principal has a duty to inform their subordinates of how the law applies, who it applies to, and how it is to be utilized. Also, you'll find that the clerk of the court, the judge, the district attorney, and the deputy prosecutor never, ever, ever have explicit permission or a letter of assignment or appointment from the Solicitor General to drag you into these foreign jurisdictions using foreign law. So this is very important to comprehend and understand, that they lack the element of standing in order to drag you into these foreign dry docks and fleece your estate. So what they're engaged in is embezzlement, racketeering, laundering, securities fraud, privateering, and treason. All right. And there are only 3 crimes in the Constitution that are mentioned: treason, counterfeiting, and privateering, or piracy on the land. All right. It's very important to understand that. So coming in qui tam, essentially what you're doing is you're coming in as a private attorney general on behalf of the United States of America, because the Treasury has the first bite at the apple. All right. And then you can bring your civil suit for damages. All right. And it's very important to understand that if you're going to go civil first, the Attorney General can come in and plead the fifth for everybody because they intend to bring criminal charges, and therefore it stifles you from pressing your civil claim. Okay. And so it's very important to notify the Attorney General, both state and federal, that you're going to go ahead and press allegations civilly, and give them the opportunity to press the criminal charges first. All right. The nice thing about letting them press the criminal charges first is you can take all their depositions and you can subpoena all the work that the Attorney General and his office did, and you can use that to your benefit, which is very, very good. All right. Because expert opinions are, although they're hearsay, they're admissible in a court of law. All right. So it's always nice to have the experts do the work for you, because they're a non-biased third party who can testify to the veracity of the facts based upon their qualifications and their expertise. All right. So Todd D's coming in qui tam. Obviously, he's given notice to the Department of Justice and the Attorney Generals, and the Attorney Generals decided they're not going to prosecute. So he's coming in qui tam as a private Attorney General, and he's going to bring criminal allegations filed against the clerk of the court, the judge, the district attorney, and the deputy prosecutor who willfully embezzled. Remember, embezzlement, RICO, counterfeit securities is what they're engaging in, and they're engaged in money laundering and tax evasion because they're not reporting it to the IRS properly. They don't have their Form 56 on file to handle the affairs of the estate. They don't have a delegation of authority, a warrant of attorney, grant of assignment. They don't have permission from the Solicitor General. And so they're in a world of hurt here. And he's hitting them for willfully embezzled the case trust securities. Okay. Now, what do you mean by securities, trust securities? Well, absent a victim, there is no crime, no corpus delicti, no mens rea, malium prohibitum. And therefore, the only thing that this can be is a constructive trust. Constructive trusts are used for purposes of artifices and schemes or constructive fraud. All right. And so what he's pointing out is that they got an advance from the Treasury on a security. What kind of security is he talking about here? What I've never heard in a court case where they identify anything necessarily as a security. Well, in Title 28, subsection E, which Title 28 is the judicial code, Title 28 United States Code, subsection E, clearly identifies a complaint as a complaint security, which means that they're getting an advance from the Treasury after the DA or deputy prosecutor or assistant DA is lodging a complaint security. The interesting thing is they don't have standing to do so. What they're actually doing is coming in as the manager on behalf of the estate without the proper qualifications. They do not have the SS-89 on file. They don't have an SF-28 on file. They don't have the Form 56 on file. They don't have a delegation of authority or a letter of appointment or a grant of assignment from the Solicitor General on file. And so what they're doing is they're attaching themselves to the estate and trust, acting as a manager without qualifications to do so. This is the importance of having your power of attorney on record, because you can prove that you have power of attorney, and now you can put them in the position where they have to prove where their delegation of authority came from. Now that you understand that under Title 28, subsection E, it's a complaint security, and Maritime Admiralty would be the jurisdiction that they're in, where they are assessing and handling vessels of the United States. It's important to know that your birth estate is, in fact, a domestic trust. It's a U.S. citizen. It's a U.S. debtor. And it is also a United States vessel. Very important to understand that. And then the Social Security juristic person, the only difference that it is, or that it carries in characteristic, legally speaking, is the fact that it is a transmitting utility. Now, they're charging up the Social Security juristic person because your estate only holds value. It doesn't have any value. So the Social Security juristic person, which is a contract between the United States and the IMF, International Monetary Fund, ladies and gentlemen, proves that there is a direct correlation between the United States and the IMF, which is in fact a contract. All this can be traced back to the significance in the creation of the birth estate through the birth application that is then there transferred to the county that keeps a record, a bookkeeping entry of the existing of your estate and your account. And then it's transferred over to the state registrar, which is the chief probate officer. The chief probate officer then creates from the application, which is the original security from which all securities are derived from for your estate, then turns around and issues what is called a certificate, a birth certificate. Now, that is not the original document, by the way, ladies and gentlemen. The one that has all the power, weight, force, and effect is actually the application. All right, so it's a derivative of the application that creates the birth certificate. And the birth certificate is, in fact, a warehouse receipt, a bill of lading. It is also a shipping manifest. It has all the proprietary information needed on it in order to negotiate it. And the question becomes, what are the rights, titles, duties, and obligations of both the parties? And what I mean by that is, what are the responsibilities, duties, and obligations of the issuer of the certificate to the holder of the certificate? And what rights, titles, and interests does the holder have holding the certificate? Well, it's very easy to see if you follow along through history, the Trading with the Enemy Act, otherwise known as TWEA, TWEA. And what it says in there, when you read it under the 40 Statute at Large 411, Section 7E, when you read the entire paragraph, it says that the president issues a document that is actually power of attorney. So you've always had power of attorney over your estate. And the evidence of that, the prima facie evidence of that, is the fact that you have that birth certificate in your constructive possession, okay? And the other thing that it does under the Trading with the Enemy Act is it issues you free passage. But you have to understand that, and that's going to be 40 Statute at Large 411, Section 7E. Now, I'm doing this all off the top of my head. Keep in mind, this is from 15 years of studying, putting everything that I talk about in action. All right, I don't just read this and talk about it. I actually do these things that I speak of, and this is how I've come to acquire this knowledge. Now, after the state register, the chief probate officer, known as the state registrar, who is, in fact, a chief probate officer, okay? And it's important to understand that the estate has already been probated, all right? And you have, unbeknownst to you, your mother, being the informant, has pledged your precious value time commodity to the benefit of the state of and the United States, the state of being a subsidiary corporation and glorified pawnbroker of your precious value time commodity, to get an advance to float government, all right? So this is where the trust comes into play. Before you can have a trust, you must first have an estate, okay? And in order to have the estate, then you have to have an account that it all links to. And this is the direct correlation between the DTC, the IMF, the United States, and the Federal Reserve Bank. So once your birth certificate is created, then the Department of Treasury is notified with the application, and the application is then negotiated between the DTC clearinghouse and the Treasury Department. And then once the DTC lodges it, the Federal Reserve Bank proclaims to have an interest in it, and there is an undisclosed beneficiary to that estate. Well, you've never given the DTC and the DTCC proper notice that you are the heir and beneficiary to that account. And so the Federal Reserve Bank walks away with the rents, profits, proceeds, futures, and annuities from the securities generated from the primary security, okay? And then once that is handled, then what happens is the United States goes into cooperative agreement with the IMF, being able to show that there's an account in an estate, and they need an account number, a Social Security juristic person created. And so there's a contract between the United States and the IMF, and the IMF is actually the one that issues the Social Security account number. The Social Security Administration administers the number. They're the administration arm of the IMF in the United States. And then, of course, you get this thing that's called a Social Security card. Now, in 1931, when they issued these Social Security cards, they were called Social Security account numbers. Social Security account numbers. Now they're just called Social Security. All this is done under Title 42, which has not been enacted into positive law, by the way. And we find the evidence of that in the 73rd Congress, First Session, Volume 77, Part 1, when they went into the agricultural crisis, along with the banking crisis of 1933 on March 4th through March 10th. 1933. All right, and if you read the 73rd Congress First Session, Volume 77, Part 1, all 1,165 pages of it, you will see where they craftfully decided that there was an agricultural lien and everybody was going to be put underneath agriculture. Okay, and that's also evidenced in Title VII United States Code, I believe it is 31, that explains that man is an animal. Anything with hair and vertebrae that breathes oxygen is considered an animal. And it's the only place in the code where they actually mention M-A-N, man, okay? And this is why you can file your agricultural lien on your biological property, such as your offspring, for stablery and livery and things of that nature. So, willfully embezzled the case trust securities after the grantor, bailer, owner, beneficiary, and he forgot one very important word here, heir. You see, H-E-I-R, you are the heir, grantor, bailer, owner, and beneficiary. Why? Because we bailed out the United States government. Okay, we are the undisclosed third-party investor and the undisclosed third-party beneficiary and heir to the United States, all right? And so when they took everything in 1933, they owe us a duty. and we are the grantor and bailer, and they are the bailee. Now, this is what the Bar Association has turned around and done. All their Bar Association agents are actually brokers. All right. Now, most of them don't have a brokerage license, but that's exactly what they're doing. They're brokering in securities, securities that you're unaware of, because although they have a duty to publish it, they don't have a duty to tell you the truth or tell you where to find this information that I speak of. Again, look at Title 28 and Section E, Title 28 being the judicial code, and you will find out that a complaint is a complaint security. Now, through usufruct, they are stealing your precious valued time commodity, leaving you on the hook as surety while denying your right to be fully availed because they refuse to give a full accounting under UCC 9-210. And as the beneficiary, you have the most powerful position when compelling the trustees to perform an accounting. All right, because how can you hold the trustees accountable if you can't see the assets and the financials that they are holding for the beneficiary's benefit, right? You can't prosecute them for being derelict in their duties if you can't see the assets and the accounts and the numbers associated with it with the double bookkeeping entry ledgers. All right, so this is the importance of understanding that you're the beneficiary, heir, bailor, and owner of these accounts. Now, on the public side, owner has tax liability. On the private side, the owner does not have tax liability. The beneficiary does not have tax liability on the private side because the money you make off my money is my money. You can't tax the king on his own money. And remember, when the founding framers came over here, they were escaping fiefdoms. They were escaping monarchies and dictatorships, all right? And they were coming over here to make sure that they had allodium, meaning they owned the land and the buildings, and they couldn't be removed from it. Okay, this is very important to comprehend. Kings without subjects is what the American people are, all right? So willfully embezzled the case trust securities. Now, in saying this, he's expressing the trust, all right? Because as you know, in studying trust law, a constructive trust can only be destroyed by expressing the trust. Well, how are we going to express the trust? We're going to express the trust by identifying the fact that under the Sixth Amendment, you have the right to face your accuser. And not only that, under the Sixth Amendment, which they're going to say only applies criminally, but logically speaking, it applies to civil matters as well. Without a victim, there can be no crime, and without somebody alleging that you trespass against them, there could be no standing for which relief can be granted. What they did statutorily speaking for these attorneys is they allowed them to file complaints, not claims, complaints under the best of their, what they state is, to the best of my knowledge and ability, I believe these facts to be true, correct, accurate, not misleading, right? To my knowledge and the best of my ability is not under the pains and penalties of perjury. So this is how you can first be able to be cognizant and recognize that nobody's actually pressing a claim against you, claiming that you caused them harm, damage, loss, a hardship, or an injury. In fact, what they're in fact doing is creating a constructive trust and hoping that you're not intelligent enough to understand that you're the grantor, bailer, owner, beneficiary, and heir of the complaint security that was filed without your knowledge, and it was ledgered and lodged with the clerk of the court. After it was ledgered and lodged with the clerk of the court, who's nothing more than a glorified window clerk for a bank, she then gets an advance from the Treasury on that complaint security, because every alleged allegation or charge that you're being charged up with, or your estate's being charged up with, behind it has a penal sum and a penal bond. And that penal bond, ladies and gentlemen, equates to financial value for double bookkeeping entry purposes and ledgering, all right? And it gets a lot deeper than that, but just to understand the basics of what's going on. So when you express the trust, if you're the grantor, bailer, owner, and beneficiary, that only leaves an heir to the trust securities that have been generated that now the trust is holding as, now the judge is holding as trustee in abeyance, because they don't know who is entitled to the funds. No qualified heir has come forward. Nobody's stated to be the beneficiary, owner, bailer, or grantor of the complaint security, all right? And as such, the judge, trustee, has plausible deniability. So you have to give the judge and the attorney, district attorney, prosecuting attorney, deputy district attorney, and the court clerk notice and express the trust orally or in written form in words on paper that you're the grantor, bailer, owner, beneficiary, and heir to the complaint security, and you're entitled to the rents, profits, proceeds, futures, and annuities that have been generated and the advance that came from the United States Treasury predicated on Title 28, subsection E. Now, if you read Title 28, subsection E, you will quickly find that you can go negotiate with the clerk of the court. They're only entitled to a fee for the transaction. They're not entitled to anything else. It's no different than any other banking organization when you put forward, let's say, a credit application. They're only entitled to a one-time fee. All right, they're glorified pawnbrokers, and what they're doing is whisking away the rents, profits, and proceeds, futures, and annuities, and they're claiming to be the beneficial heir to the proceeds that are being held in abeyance. And they create what is called a discretionary trust to block you from those proceeds, all while hiding the true nature and cause of the transaction. Okay, they're never going to tell you that it's banking, that it's done under maritime admiralty law, that they're presuming and assuming there's a contract, that they're presuming and assuming that they have the authority to do these things, that the district attorney is actually acting as a manager on behalf of your estate, charging up the cestui person and creating a cestui trust, charging up the Social Security juristic person as a transmitting utility. Now, they need you, the third person, to come in and release the credits, okay? This is what they need you to do. They need you to release the credits. And you don't want to do this waiting for the 30 days for your general appearance, okay? You want to do this on paper right away and let them know that you know what's going on. So willfully embezzled the case trust securities after the grantor, bailer, owner, beneficiary, and secured party revoked and revested the securities. This is a very good word right here. Revested the securities by way of assignment on the UCC1, which is the commercial chamber, the securities, and filed the UCC1 liens, IRS paperwork, and securities not only for set off and discharge, which is also articulated in the Trading with the Enemy Act, as well as the 73rd Congress First Session, Volume 77, Part 1, of the commercial liabilities, because that's what this complaint security creates, is commercial liabilities, but arrested and attached the bar members' bonds to pay the taxes due. So their bar card number, ladies and gentlemen, is a bond number. And so when you do the SF-28, you utilize the judge's bar number, the district attorney's bar number. You can attach their bond numbers to it. And the reason that you're doing the SF-28 is so you can exercise the right of subrogation and subrogate to the SF-28 bond. Now, when you fill out the SF-28 bond, you're going to give them the original, the clerk of the court the original, and you're going to get certified copies back from the clerk of the court showing that they received it, and then you're going to turn around and send that off to the GSA proper authorities, okay? Because the court, the lower inferior courts under Article 1, Section 8, Clause 9, are not reporting to the GSA. They're not reporting to the Inspector General of the GSA. And so it is your duty incumbent upon you to take the SF-28 and make sure that the Inspector General of the GSA has certified copies from the clerk of the court of you exercising your right of subrogation. See, when the judges, the DA, the clerk of the court create these complaint securities and ledger and lodge them to get an advance from the Treasury, under Title 26, 2032, AE 11, they are required to be independently bonded with the Secretary of Treasury of Puerto Rico. Mind you, none of them are independently bonded. Now, what is that bond cover? What is that bond for? That bond, ladies and gentlemen, is to cover the taxes due and owing. But see, they didn't have permission from the Solicitor General in the first place to attach themselves to your estate and to charge up your juristic person. Okay, so they wrote a check their asses can't cash, and now they're in a humdinger about it. And they're not reporting under Title 26, under the IRC code, which they're mandated for doing business in the United States. They have to be compliant with the Internal Revenue Code and the Internal Revenue Manual, ladies and gentlemen. That's why it's important and imperative that you grill them about not having the Form 56 and you demand that they put it on record for your inspection. Okay, so something you can do in a court case is you can FOIA the docket number and case number to the IRS, demanding the 1099-A that the clerk of the court filed on behalf of the district attorney and the district court judge or the county court judge, and they will send that to you under the Freedom of Information Act, showing that the lender, in fact, on the 1099-A is the United States Treasury, and the recipient of those advanced funds from the complaint security, which belongs to you as a grantor, bailer, owner, beneficiary, and qualified heir, were sent to the actual court and are in constructive possession of the judge, who is the trustee. All right. Now, once you have that information and you're armed with that information from the IRS, you can submit that into the court case, although it's highly advised not to do that, but rather give them private notice on the private side using registered mail or certified mail with a 3811 green return receipt, proving that all of them have been put on notice of the advance they got and that they owe you a duty. Because if they don't disperse those funds through the disputed ownership fund to you, then they're liable for the transfer taxes on a carryover basis under Title 26, 2603, 2602, 2001, and 2002. Anybody in constructive possession of decedent estate property is liable for the transfer taxes on the carryover basis. Now, I've been talking about this stuff for years and years and years, thanks to Smoke and Baby and so many other of my mentors that are just brilliant beyond brilliant. Most of them are tax experts. Some of them are just highly qualified in comprehending the law and how it reads. They've been to prestigious schools. Some of them are much like myself, self-taught, and have succeeded many times in many different cases. So with that being said, now we need to look at the next part of this. The named parties are technically trustees, D's on tort. This is important. They're trustees because of the nature of their business. All right. They took an oath to the Constitution, and equity imputes an intention to fulfill an obligation, but more so, trust law supersedes all other law. And we can verify that by looking at Summa Corp versus the state of California, when it points out that treaty law is the highest law and supersedes the constitutions in all 50 states and the Constitution, federally speaking. However, all of these constitutions and all of these treaties are predicated on trust law. So the named parties are technically trustees, D's on tort, under Title 50, United States Code 4312. Now, this is where the DA 2838 or 2848 comes in. It's not a power of attorney form. It is actually an affidavit form. And the reason that we're doing the DA affidavit form, which is the Army form, is because they fall subject under Title 50. Remember, in administering the bankruptcy under foreign occupation, everything goes through the DOD. The Federal Reserve notes, which are floating rate notes, are actually military script, and everything is done under Title 50, United States Code 4312. A physical agent of the Treasury, Title 12, United States Code 266 of the Internal Revenue and U.S. Treasury Department, whether they want to admit it or not. This is very important information here. So then he gives the list of the names of the judge and all this. And mind you, they're all using false and fictitious, unregistered, assumed business names, which is a violation because they're acting as attorneys trying to turn your property to their principal to unjustly enrich themselves while engaging in money laundering, human trafficking, trafficking of persons, so on and so forth. And they're doing so with false and fictitious names, so you can't hold them accountable. It's a little trick that they thought they could pull off on the American people, and quite frankly have done for about 160 years. But due to the advent of technology and people like myself and so many others like yourselves, we're catching on to their little fucking slide scheme, all right? And it is a scheme and an artifice, undoubtedly. So he lists the prosecutor, the district attorney, the deputy prosecutor, and also the clerk of the court. This person has no oath of office and no security license and no surety bond. Now, dealing with securities, they have to be licensed as a Class 7 series or Class 10 series broker. They are not. What they do have, however, is the CRIS system, and they're utilizing the state as a glorified pawnbroker, which is a subsidiary corporation of Washington, D.C., the District of Columbia. The District of Columbia and Washington, D.C., known as Capitol Hill, the 10 square mile area, articulated in Article 1, Section 8, Clause 3, and as well as Article 1, Section 8, Clause 17, 13, and 14, clearly points out that the jurisdictional area is territorial by its nature, and that the federal government has the strict authority over maritime admiralty contracts and awards and penalties and violations of such. Okay, so the federal government is the one that handles the maritime admiralty jurisdictions. The lower courts try to extend that by saying they have extraterritorial jurisdiction under the minimal contact doctrine, which is a farce. So this is why I advocate under Title 28, 31, 1331 and 1441 that you roll everything over under diversity of citizenship or a constitutional question to the federal court. So under Title V, United States Code, subsection 3331 through 3333 and 7311, treason and sedition and striking, which also includes insurrectious behavior. As I articulated to you earlier, there are only 3 crimes listed in the Constitution. You have treason, you have securities fraud, okay, counterfeiting, which is securities fraud, hypothecating United States securities into existence without authorization, and then, of course, privateering, which is found in Title 18, United States Code 1661. Granted that Title 18 is not enacted into positive law, however, you're going to be taking them into the deep waters. You're going to be taking them into the federal court, which has exclusive jurisdiction over maritime admiralty contracts for damages and awards, all right? If you're looking at equity per se, you wouldn't be looking for damages and awards. What you would be looking for would be maybe an estoppel or a permanent injunction, things of that nature. Typically, the exclusive jurisdiction of equity does not deal with monetary awards, but rather compels people to perform or to cease and desist the actions that they're engaged in. All right, so it's important to understand the distinctions in those jurisdictions to yield the remedy that you seek. All right, under Title V, United States Code 3331 through 3333, they have to have an oath of office and they have to have an SF-28 on file. The SF-28 is a sworn affidavit under the pains and penalties of perjury, and nobody from the highest position in government to the lowest position of government has an SF-28 on file, ladies and gentlemen. I've got a number of constituents and friends who have brought this to the attention of the Congress, the legislature, the House assembled, to district attorneys, all 50 state attorney generals, and so on and so forth, and everybody has shied away from it. In fact, a number of judges have recused themselves, saying that they can't partake in any suit due to the lack of their ability to maintain a non-biased position, because all of them are acting as government agents and none of them are actually filling the seat of government. That's why they don't have their SF-28 on file. They also don't have their Title V United States Code 3332 or 3333 or their anti-bribery statements properly registered and filed as well. And then under 7311, they are engaged in treason and sedition and also insurrectious behavior and striking, all right? Willful crimes charged. Title 18, United States Code 1028A, which is aggravated identity theft. Every time they hypothecate your good name into the public, okay, which your good name is private, but they're putting it into the public and they're generating a complaint security, operating as a manager, not having their their Form 56 on file to administer the estate, not having their independent bond under Title 26, 2032, AE 11 with the Secretary of Treasury of Puerto Rico. You may wonder what the significance of the Secretary of Treasury of Puerto Rico is. That's where our trust is set up, ladies and gentlemen. That trust belongs to us. That's why it's single and separate and distinct from the United States. Remember, the United States is nothing more than a glorified property manager, and they only have control over the things that have been ceded to or owned by the United States. Okay, and so they're taking your credit, they're running off with the proceeds, and they're leaving you as surety, and they're putting you in their private for-profit prison system, or getting you to join one of their multitude of programs, whether it be the blow and go or probation or some type of mental health evaluation. They're all silent investors in these different organizations that most often are 501c3 charitable organizations, and they're invested as silent investors for profits and proceeds, okay? So under Title 18 United States Code, subsection 1028A, aggravated identity theft, the sheriff, the district court clerk, the county court clerk, the district attorney, the deputy attorney, and the judge are all involved in this. They're running their own private little fiefdom, their own private little business that has a Duns and Bradstreet number, and you need to demand their W-9. Their W-9 proves that it's commercial in its nature, which is evident under Title 27, 7211. All crimes are commercial in their venue, okay? So they're presuming and assuming under maritime admiralty law that there's a contract there. This is why the district attorney and county attorney write up the complaint security stating that you are a resident, that you live at 12356 10th Street. These are all rebuttable presumptions, all right, ladies and gentlemen. And that you knowingly, willingly, and intentionally violated this this statute, this code, this ordinance, this rule, this regulation, all while not proving that you're subject to the jurisdiction. It's prima facie evidence. On its face, it appears that you're subject to it, but there's no physical evidence behind it proving that you are. Therefore, they lack standing. This is why we always challenge venue, standing, then territorial jurisdiction, subject matter jurisdiction, and in personam jurisdiction, all right? Because they have to prove that this stuff applies to you. It applies to them, most certainly, but it does not apply to you. Title 18, United States Code 371, conspiracy to commit offenses or to defraud the United States. Ladies and gentlemen, that's exactly what they're doing when they're counterfeiting United States securities. They're writing the check that their ass can't cash, they can't cover the taxes, and they're hoping that you will come in your ignorance and sign for it as the liable party. Title 26, United States Code, subsection 7201, attempt to evade or defeat taxes. All right? They're engaged in tax evasion. All right? And as such, they are liable because under Title 26, 2603, 2602, 2001, and 2002, anybody in constructive possession of decedent estate property is liable for the transfer tax on a carryover basis. That means when the officer on the side of the road issues you a citation being a good thing in the military, by the way, they're actually giving you money. When they issue that citation on the side of the road, and then that officer takes it to his superior officer, there's a transfer tax owing because the security becomes a commodity. And as long as that commodity is in motion, it's a commodity and it's a non-taxable event. But the second the transfer happens and it stops with the other party, that commodity then becomes money and is a taxable transaction. So when the citation goes from your hands to the officer's hands, that's one transfer tax to an owing. Then when it goes from the officer's hand to his superior officer, that's another transfer tax to an owing. Then it goes from his superior officer to the district attorney's office, that's a transfer tax to an owing. Then it goes from the district attorney's office and is ledgered and lodged with the clerk of the court, that's another transfer tax to an owing. And then with the advance and everything that goes on, the complaint security and the ticket citation are given to the judge, and that's another transfer tax to an owing. So just in that scenario alone, there's 5 transfer taxes doing an owing because that security, as long as it's in motion, is considered a commodity. The second it stops moving and lands on somebody else in somebody else's hands and somebody else's account, once it lands, it converts back to money, and there's a taxable event under the transfer tax under Title 26, 2032, Title 26, 2603, 2602, 2001, and 2002, anybody in constructive possession of decedent estate property is liable for the transfer tax on a carryover basis. And that's why they have to be independently bonded under Title 26, 2032 AE 11 to cover the transfer taxes. All right? Now, I know I'm speaking fast, and you'll have to listen to this a few times to completely understand it and comprehend it. But what I'm expressing to you is how you can come in as the qualified heir, beneficiary, bailor, and owner of that complaint security. All right, and you're owing the rents, profits, proceeds, futures, and annuities from the monies that they created by hypothecating your credit into existence, absent your knowledge and without consent or a delegation of authority to do so. Under Title 26, United States Code, subsection 7206, fraud and false statements and concealment, which is also a violation of Title 18, United States Code 1001, false and misleading statements, or using a false conveyance of language in order to ensnare people in an artifice and a scheme in order to unjustly enrich their principal, which bolsters their retirement and pays them. All right, so under Title 26, United States Code 7206, fraud and false statements and concealment. They're concealing material facts from you, failing to disclose material facts or misrepresenting material facts. In any case, it's the same. All right, and they're not telling you the true nature and cause of the transaction is administering the bankruptcy so they can unjustly enrich their principal on some hypothetical guise that you're subject to statutes, codes, city ordinances, rules, and regulations, absent a visible contract. Now remember, the contract can't be false and misleading. It can't omit material facts. They cannot use false and misleading and deceptive trade practices and a conversion of the language in order to ensnare you into a manufactured consent, which is what they're doing. Under Title 26, United States Code 671 through 677 deals with embezzlement, which is exactly what they're doing. They're embezzling from your estate, which is directly tied to the bankruptcy. The national debt actually belongs to we, the American people. That's why businesses are required to pay taxes. It's not to float government, it's to pay us back for the advance that the United States got from us when they took the gold and silver in 1933. Now, I know you're gonna spank me on that and say, well, they didn't take the silver. Look, when you give them something of value, but they don't give you any consideration in return, that manufactures a trust. A trust manifests from that very action. They automatically, by default, become trustees. Remember, he who provides the ends provides the means. So they create all these statutes that are tied to penal bonds and penal sums, and it's done through the legislature and the Congress. Guess who's liable for it? If I ask you to build me a house and on Monday morning you show up with 8 guys, but I don't have the lumber and materials there, who's liable for paying the employees? I am, right? Because I was derelict in my duty and didn't have the materials on ground. And if I provide the ends, I must provide the means, which means I'm the one that's liable. I carry the primary active degree of fault for your employees standing around with their thumb up their ass. I still have to pay them. You don't inherit that obligation. I do, because I was duty bound to make sure that you had the materials to build the house. I hope that makes sense in the most simplest explanation I can come up with. Under the SEC Rule 10b-5, 10b-5, tax evasion, okay, they're engaged in tax evasion and money laundering, not and as well as securities fraud. Under Title 18 United States Code, subsection 472, uttering counterfeit obligations or securities. Now, it's really important under Title 18, subsection 472, to go look at what the word uttering actually means by definition. Okay, to paint in a false light, to create a false narrative, to commit fraud by false and misleading and deceptive trade practices using a false conveyance of language to lead somebody to believe they owe an obligation, all right, which is called manufactured consent. Under Title 18 United States Code subsection 475, imitating obligations or securities, imitating obligations or securities, which is exactly what they're doing when they pull you in there and say, you know, we need your name. If you don't give us a name, we're going to hold you in contempt. One of the quickest ways to reverse that is the Uno reverse card. Just bring yourself some Uno cards into the court and say, Uno reverse, is this honorable court trying to get me to engage in perjury and purge myself by claiming something that I know not of with firsthand perfected knowledge? I can't tell you what name I have because it's hearsay. All right, so if you're trying to get me to purge myself under threat, duress, and coercion, I just beat the case. All right, and of course, anybody that's smart sitting on the bench, and smart does mean painful, is going to quickly realize that they carry the primary active degree of fault for coercion by threatening you to claim something that you don't own, which is theft by taking. All right, and you're doing so under threat, duress, and coercion via disarms because they've got some thug in there that's going to cost you against your will if you don't agree. That, again, is called manufactured consent, and it's a violation of the law. So you just simply ask them, are you attempting to get me to commit perjury under threat, duress, and coercion, threatening me with contempt of court if I don't claim something that I have no firsthand perfected knowledge of? And of course, if they're intelligent, they'll say, oh, absolutely not, absolutely not. Good, well, then I'm here to express the trust. Okay, the complaint security filed by the district attorney or the deputy district attorney was without my consent, and the money you make off my money is my money. Otherwise, under Title 26, 2032 AE 11, you're supposed to be independently bonded to cover those tax obligations from the advance you got from the complaint security, which was unauthorized. And I'm not signing off on anything or releasing the credits until a full accounting is done and we understand who carries the primary active degree of fault for the taxes and the assessment. All right, under UCC 9-210, I'm demanding a full accounting. Now, you're going to do that privately, of course. If you do that in the public record, they're going to make all kinds of accusations. You're a sovereign citizen. You don't know what you're talking about, yada, yada, yada. Look, I'm telling you right now, when you do a 4506A, 13909, 3949A, and a 211 form, which is a whistleblower form that'll get you 30% gratuity for reporting to the IRS, because again, it's our duty to make an observation, create a record, and report it. That's it. Nothing more, nothing less. We don't have to go beat our little war drum, but we do need to take it upon ourselves to express the trust, which absolutely destroys the constructive trust, because we're going to come in as the owner, beneficiary, the grantor, bailer, and heir to the securities and new monies created on the account. All right. Title 15, subsection 1, subpart 1, interference with trade and commerce, or restrict on trust in restraint of trade. This is very important. It comes at $100 million for the corporation that's doing it, and I can assure you private local court is a corporation that is engaged in interfering with the private trust and restraint on trade and commerce, which is a $100 million violation for them, as well as $1 million for each agent and agency engaged in it. Then, under Title 18, 1005, Title 18 United States Code 1005, anybody engaging in banking, issuing decrees or judgments is a 30-year prison sentence and a mandatory $1 million fine. All right, so it's important to write that down because that is not included in here. But what they are doing is banking, and they're all engaged with the Bank of International Settlement, which has nothing to do with the Union of States. Okay, it's foreign and it's underneath the EJAC Corporation. All courts are EJAC corporations. They're either negotiating your securities with the stock market or they're taking it directly to the Forex, which is the largest foreign currency trade market in the world that's located in Paris. In any case, they're doing all of this through the Bank of International Settlement, which is outside of the United States. And if you read anything on the banking laws and you read anything about the statutes at large, you will see that Andrew Jackson proved single-handedly that the Congress was never with the delegation of authority to create a national banking organization or system. So they're interfering with the trust and restraint of trade and commerce, which is a violation of Title 15, subsection 1, sub part 1, which is a $100 million fine and $1 million for each agent engaged in it. They're also violating Title 18, United States Code 1951. They're engaged in RICO racketeering. The nice thing about alleging RICO is you don't have to prove RICO, all right? You don't have to go through and prove all the elements. You just simply have to allege it and then point out the agents and agency you believe to be engaged in it and show to a slight degree as to why you've come to conclude that. Well, it's pretty simple when you're demanding a full accounting and they refuse to give it. That in and of itself, pointing out Title 28, Section E, that complaint security is in fact a security that is lodged and ledgered with the Treasury in order to get an advance from the United States Treasury to float the bonds and securities that they're creating. Now, Title 15 United States Code, subsection 2, monopolization of trade. They are not operating under Article 3. Ladies and gentlemen, they're operating under Article 1, Section 8, Clause 9, which is lower inferior courts dealing with maritime admiralty jurisdiction, which is exactly why you have a right, an unalienable right, to demand the nature and cause of the transaction, because it's most certainly not criminal. So the only other element that it could be is civil. And so we demand to see the contract that we knowingly, willingly, and intentionally entered into, waiving our rights, making us subject to some type of contractual nexus, giving you extraterritorial jurisdiction over the matter in maritime admiralty jurisdiction through minimal contact doctrine. Of course, they can never prove that or produce it because all of your applications are in fact securitized and they never hold the originals, ladies and gentlemen. A certified copy or a copy is nothing more than a masterful forgery, which puts the onus of probandi back on the district attorney. Of course, if you study Tinsley versus Pagliaro, statements and arguments made in brief, although flattering to the court, do not grant rise to summary judgment or a motion to dismiss. In other words, if you don't have firsthand perfected knowledge and you are not a real party in interest that's been directly affected by this, you cannot submit evidence into the court. And if you're going to attempt to do that, we are going to turn around and subpoena you as a witness, which means you can no longer represent the entity you're representing because you have firsthand perfected knowledge of facts, and that makes you a witness unqualified to actually be the representation on behalf of your principal. All right, so they've monopolized the industry, going into special star chambers venues where they have monetized justice, meaning if you pay enough, you can get what you want. Okay, the other reason that they're charging in these courts these fees for filing a claim is because they're misappropriating your position and status. See, the courts are open to the people by way of right. It's an unalienable right to redress your grievance in a court of law, in a court of competent jurisdiction of a court of record under Article 3. All right. In the Article 1, Section 8, Clause 9, they're presupposing and presuming and assuming that you're representing an entity, and therefore you have to pay a fee. The reason that you have to pay a fee is because corporations, businesses, trust don't have an unalienable right to redress of grievance. It's a privilege to use we the people's courts to find remedy in those venues, and therefore you have to pay a fee. So when they're telling you that you have to pay a fee to get a redress of grievance, justice shall be had freely, without delay, and without cost. Remember, justice delayed is justice denied, and merely implying that you have to pay a fee in order to get a redress of grievance in a hearing before under the Seventh Amendment, your right to trial by jury, which is not the same as jury trial, is in fact justice delayed, which is justice denied, making the agents who are pressing you about filling out improper paupers forms or paying some benign fee in the interest of justice, ladies and gentlemen, is in fact a denial of due process of law, and it constitutes baratry. It also proves that they're malfeasant in office. It's malicious in its nature to presume and assume that you are representing an entity when you're clearly coming forward in your proper capacity in propria persona sui juris as a sojourner on the land, not subject to the statutory edicts that they've put forth. Remember, under Article 1, Section 8, Clause 3, Congress was only authorized to create statutes, codes, city ordinances, rules, and regulations, and legislation that pertain to trade and commerce, okay, for profit and gain, not to lord over the American people. All right, the Constitution is very clear about that, and it is, in fact, the law of the land. They are bound by it. It is the trust that you can hold them accountable to. Now, in order to understand everything that I just went over there, because it's a lot and it's just all off the top of my head, ladies and gentlemen, and forgive me if I've made a mistake here and there, because I may have. All right, I'm dyslexic. I have dyslexic tendencies, so some of my numbers do get mixed up from time to time. So, as I've stated 1,000 times, and I'm sure I'll state 10,000 more, there is no substitution for reading. Please do not take my word for anything. Go and verify everything that I'm talking about. Statutes to enforce the GAAP and GAAP accounting for the court's IRS accounting records and bid, performance, and payment bond. That would be in the county court and district court of the state. That would be SF 24, 25, and 25A. Bid bond, performance bond, payment bond. There's also warehouse bond as well for warehousing the body as surety. All right, so you got the bid bond, performance bond, and payment bond, SF 24, 25, and 25A. On the federal level, it's going to be 273 SF standard form, 273, 274, and 275. Under Title 26, Code of Federal Regulations, Chapter 1, Subpart 1.149-1, imposition of taxes. Okay, now you may be wondering, why are we using the Internal Revenue Code and the Internal Revenue Manual? Ladies and gentlemen, in order to do business domestically in the Union of States, they all had to go in a cooperative agreement and agree, okay, because it's a trust, agree to abide by the Internal Revenue Code and the Internal Revenue Manual. That's every bar association, that's every business. They're all administering a bankruptcy. Every business that's registered with the Secretary of State is, in fact, a debtor and is in fact insolvent. Under Title 26 United States Code, subsection 108.14b, income from discharge of indebtedness. Okay, they are supposed to offset and discharge everything, ladies and gentlemen. Under Title 18 subsection 8, all obligations are obligations of the United States. It also says that in the 73rd Congress, First Session, Volume 77, Part 1, that the securities issued by the American for whatever they need is not to be reissued. It is actually supposed to be terminated, and the Treasury and the Comptroller of the Currency are supposed to zero balance the ledger. Title 26 United States Code, subsection 6049, returns regarding payments of interest. Okay, when they're securitizing all of this stuff and they're putting it into the stock exchange for the next 30 to 40 years, it yields dividends, derivatives, debentures, hediments, general intangibles, trust residual, trust residue, rents, profits, proceeds, futures, and annuities from the investments. All right, so this is everything they're dealing with. They're dealing with chattels. So you want to know your rights, titles, interest, dividends, derivatives, debentures, hediments, general tangibles, general intangibles, chattels, securities, trust residuals, trust residue, rents, profits, proceeds, futures, and annuities generated from the complaint security that was unauthorized, which is considered counterfeiting United States securities without authorization, which is piracy, and it's also privateering. All right, and so they have a duty under Title 26 United States Code, subsection 6049, returns regarding payments of interest. Okay, because when they put these into the market and they're securitized, there's interest in futures and annuities that are distributed month after month after month that you're entitled to as the heir, as the qualified heir, as the beneficiary, as the bailer, because remember, they're the bailee, we're the bailor. They're the ones that are in bankruptcy. We are not. We are the sovereign, we are the real party in interest, and we are the creditors, so saith the Congress. Title 26, United States Code 6103, confidentiality and disclosure of returns and return information. All right, they're trying to hide behind the fact that those are all confidential records and you're not entitled to them, but you are in fact, okay, the heir, the beneficiary, the grantor of the complaint security, and you're entitled to full disclosure of all the information, including the returns. The reason they don't want to give you the 1099-A is because they've got box 5 left blank instead of checking box 5 that they're responsible for repaying the advance they got from the Treasury, ladies and gentlemen. And because you're unaware of that, you haven't corrected the form where you, on the 1099-A, you check box 5 and then do a correction at the top and you mail it back to the IRS, making them liable for it. The only thing that would stop them from being liable for it is if they actually gave you the check they got in advance from the Treasury. All right? And I know these things from the clerk of the courts that I've grilled and drilled that say, well, there is one more thing in the file. Oh, yeah? What would that be? There's a check. Well, in my youthful ignorance, instead of demanding whose name is on the check, I demanded that they give me the check. What I should have done is said, whose name's on the check? Who's the principal listed on the check? All right? Because now I need to see your guys' power of attorney, your letter of appointment, grant of assignment, delegation of authority to be in constructive possession of decedent estate property. Where's your Form 56, your SS-89 on file? Where is your SF-28? Where's your delegation of authority, letter of appointment from the Solicitor General to utilize any of this information in a private for-profit jurisdiction under Special Star Chambers venue outside of the judiciary? Show me where you got your delegation of authority. And of course they can't. So under Title 26, United States Code 6713, disclosure or use of information by preparers of returns. All right, we need to know who created that 1099-A that's directly linked to the bank account known as a docket number, a case identifier, case number, and we need to know who prepared those forms because we didn't authorize them to prepare those forms. All right, Title 26, United States Code, subsection 7213, unauthorized disclosure of information. This is the identity theft that we're talking about. Who granted them the authority? Where's their power of attorney, delegation of authority, letter of appointment, license grant deed to utilize that intellectual property and that special proprietary information that belongs to the beneficial heir, the beneficiary, the grantor, bailer? Who authorized them to use that? Okay. Title 26, United States Code, subsection 7214A1, 1 through 9, offenses by officers and employees of the United States. All right. This is where they get held liable in the Internal Revenue Code. All right. When you demand the W-9, that kicks in an investigative proceeding because there's a $50 fine attached for anybody that does not provide their W-9 when required if you're doing business with them. Understand that this is just business, ladies and gentlemen. Absent a victim, absent a crime, no mens rea, malium inse, malium prohibitum, or corpus delicti. Ladies and gentlemen, this is nothing more than a constructive trust used as fraud to embezzle, engage in money laundering, tax evasion, RICO, all at your expense. Okay? And so this is important to understand. Title 26, United States Code, subsection 7214A1, A, 1 through 9, offenses by officers and employees of the United States. They have a duty to report under Title 26, 2032, AE 11, Title 26, 2603, 2602, 2001, and 2002. Anybody in constructive possession of decedent estate property is liable for the transfer tax on a carryover basis. When they're not doing it, ladies and gentlemen, nobody qualifies for 11th Amendment immunity from stealing from your estate. Nobody has 11th Amendment immunity from the IRS that's engaging in what they're doing. All right, so when they say they have immunity, you can laugh. Title 26, United States Code, subsection 7216, disclosure or use of information by preparer of returns, means that once you do your FOIA request, you will find out who exactly made these unauthorized transactions, and now you can hold them accountable for it. Under Title 26, United States Code, subsection 7851, applicability of revenue laws. Well, as I told you all before, the Bar Association, in order to do business domestically in the several states, and the Union of States had to go into a cooperative agreement and agree to be bound by the Internal Revenue Code and the Internal Revenue Manuals in order to do business domestically. All right, so under Title 26, United States Code subsection 7851, applicability of the revenue laws shows you that they are all bound by Title 26. Now, there are people out there that say Title 26 has never been enacted into positive law. The 16th Amendment was never properly ratified. That's right, because it's an offer to contract guised as an amended right, okay, or compelling people to perform certain duties. Well, agents and agency do have a duty and obligation to pay taxes because, after all, that's what the tax is for. Pay special attention to Title 26, United States Code, subsection 7206. 3. Fraudulent bonds, permits, entries, simulates, or falsely or fraudulently executes or signs any bond, permit, entry, or other document required by the provisions of the Internal Revenue laws or by any regulation made in pursuance thereof, or procures the same to be falsely or fraudulently executed, or devises, aids in, or connives at such execution thereof, or for removal or concealment with intent to defraud, removes, deposits, or conceals, or is concerned in removing, depositing, or concealing any goods or commodities. Remember, I told you that a security in motion is a commodity. It's a non-taxable event until what? It lands. Once it lands under Title 26, 2603, 2602, 2001, and 2002, anybody in constructive of deceiving of state property is liable for the transfer tax on a carryover basis. The minute that it lands, it's no longer a commodity, it's money, and it's a taxable transaction, okay, for the transfer taxes on a carryover basis. For or in respect whereof any tax is or shall be imposed, or any property upon which levy is authorized by section 6331, with intent to evade or defeat the assessment or collection of any tax imposed by this title. Again, the reason they're collecting taxes, ladies and gentlemen, is because they're waiting for you, the American people, to come back in and claim your living estate. All right? The decedent estate is something that is dead. Then you have the living estate. One of the reasons you have a decedent estate is because it is not seeded yet. You haven't returned the warehouse receipt, the birth certificate yet properly and made your claim. All right. So with that being said, I hope this helps you out with the Quaitam criminal charges approved and ordered in the U.S. Tax Court petition, because I've been telling you guys this for about 10 years now. Smoking Baby's been telling you about how important the IRS is. And I just wanted you to understand the language within this and why this is so important. And again, I believe this was filed 3 weeks ago, ladies and gentlemen. And it was approved. It was approved. And this is huge. I talk about this all the time, Title 5, 3331 through 3333. But I also express that equity impedes an intention to fulfill an obligation. So I don't give a shit that none of their oaths are proper, that they don't have the SF-28, they don't have the Form 56, they don't have the 38, the SSA 98 on file. I don't care that they don't have any of this stuff. All it does is weigh heavily on proving my point, all right, that what they're doing is fraud, that what they're engaged in is aggravated identity theft, extortion, baratray, human trafficking, trafficking of persons, embezzlement, tax evasion, all right, uttering counterfeit obligations or securities, all right, and so it all lends to the fact that they're not authorized or qualified to do so. So they're engaged in treason, sedition, and insurrectious behavior, mixed war against the Constitution, and they're taking their income under false pretenses, which is theft by way of false promises. They can go to prison for the rest of their life. Title 15, subsection 1, subpart 1 says they're not allowed to interfere with trade and commerce, which is exactly what they're doing, which is exactly why we bring these issues into the federal court and the United States Tax Court, which is the highest taxing authority in the United States. With that being said, let's get to our rights, shall we, ladies and gentlemen? In order to have rights, one has to have a duty to observe them, and the other one has to be able to express them. So one has a duty to protect, and the other one has a duty to enforce. Does that make sense? You can't have rights if somebody else doesn't have a duty and an obligation to protect them. All right. So Robin versus Hardaway, 1 Jeff 109, Virginia, 1772, recognized inherent rights retained by citizens, supporting exemptions from regulatory overreach in non-commercial contexts, ruled that Indian slavery was illegal in Virginia for most of the 17th century, establishing that descendants of enslaved Native Americans were presumptively free, and invoked principles that legislative acts contrary to natural rights and justice are void. All right. And so what's the important of pointing this out? Oh, well, Derrick, this is before 1776 or 1789. It doesn't have any real relevance. I would implore you to go read the Sixth Amendment, or Article 6, to the Constitution, which clearly points out that any contract, treaty, or debt that occurred before the adoption of this Constitution is just as valid as after the adoption of this Constitution, again, leading to Article 4, subsection 1, full faith and credit. They're going to say that this is persuasive but not controlling, and I would say that you use the invocation of Article 4, subsection 1, full faith and credit clause, all right, and Article 6 to prove that, any treaty or agreement entered into before the signing of this Constitution, including the debts, are as valid as after the adoption of this Constitution. So Robin versus Hardaway, 1 Jeff 109 VA, 1772, the reason I'm pointing it out is it's talking about natural rights. Remember, in the Declaration of Independence, the only reason that it went through, the first draft didn't go through, it was the second draft that went through, and there's a long story behind that, but there were essentially 8 horsemen that rode what was called a circuit, and they preached the good Lord's word, okay? And the soon-to-be government, the Continental Congress, understood that these people were highly valued amongst the community, so they wanted their blessing on the Declaration of Independence. And they said that they would not bless the Declaration of Independence because it lacked integrity, wherein it did not state and proclaim that the law was that of the law of nature and nature's God. In other words, recognizing the Heavenly Father as controlling in natural law and nature's God. And so that's how you ended up getting natural law and nature's God in the Declaration of Independence, all right, just a few short years after this case from 1772. And here we again are articulating natural rights, and we're talking about presumptively here, presumptively free, all right? But it's a fact that all men are created equal, all men are free. Nobody is subject to the legal confines of another absent a valid contract, okay? And there's only 4 ways to have a valid contract. The individuals that are involved in it, the men and women that are involved in it, must mutually assent of the mind and assent to that which they contract to. The contract cannot be vague and ambiguous in any way. There could be nothing illegal or unlawful in the contract, and they must be of age of majority, and they must do so by giving their free will and consent. All right, so that means nothing can be vague and ambiguous. There can't be any false and misleading statements, or omitting of material facts, or concealment of material facts, or misrepresenting material facts in order to manufacture consent. So on its face, the contract looks legitimate, but as we start to go through the elements of what creates a binding legal and lawful contract, the parties must be age of majority, must be of sane, sound mind. It must be mutually beneficial for all parties involved, okay? And there can't be anything in the contract that would be unlawful or illegal, all right? It has to have a start date and an ending date. It has to have value and consideration. All right, so the Robin versus Hardaway, 1 Jeff 109, Virginia, 1772, recognized inherent rights, unalienable rights, natural rights retained by citizens, okay? Now, I'm a citizen of heaven. I'm not a citizen of the United States, because I understand that you can't be a citizen of Walmart or a citizen of Target, okay? You can be an employee subject, and you can volunteer to be subject to their edicts if you wish, but under your unalienable rights, under the law of nature and nature's God, you cannot be a citizen. In fact, it's incomprehensible that anybody would allege to be a citizen. I'm a citizen of heaven, okay? And I have natural rights, unalienable rights, okay? Recognized inherent rights retained by citizens, supporting exemptions from regulatory. What does that mean? Exemptions from regulatory. Let's break it down. Exemptions mean that they have immunities, right? That they have no obligation. I'd rather say that they have impunity from any regulations. What are the regulations they're talking about here? The regulatory system. Well, the regulatory system would be the statutes, codes, city ordinances, rules, and regulations created and derived by Roman law, or the law of the Pharisees, or the law of the alleged government, right? Unless you are a willing volunteer or participant, or you have contracted with them, you're not subject to their statutes, codes, city ordinances, rules, and regulations. That is what they considered overreach in 1772 in non-commercial context. In other words, they're pointing out to you that the only thing they have jurisdiction over is commerce, the law of mercantile, the law of merchant, okay? And that's what they're governing. Contracts. Contract creates the law and equity follows the law, okay? The reason I'm explaining this on such a deep level is I think a lot of people it goes over their head. And I know I'm going fast, and we're going to have a class coming up soon to explain more of this. Cool Fox and I have decided to get together. He specializes in treaty law and natural rights, and he's won a number of cases from the East Coast to the West Coast. Again, he's not an attorney. He's just a man that's very learned in law and goes into private contract with all these different organizations where they elicit his help and grant him power of attorney to put together the paperwork and help represent their tribes and their nations and bind the government to the treaties and agreements that were entered into prior to the Constitution. Republica versus Swear 1 U.S. 41, 1779 upheld the conviction for forgery and fraud against the United States during the Revolutionary War. Now, understand the Revolutionary War. We have the Reorganization Act of 1871. War is started by a declaration, and war is ended by way of proclamation. The one who ends the war had to have been the one that started it. Well, they euthanized old Abe Lincoln there, and so he never issued a proclamation to end the war. So technically, we had been at war this entire time. Since the Civil War, establishing that the United States could be treated as a body politic, and this is very important, this word here, or, is an audible, or a corporation. Now, this is where you're finding Title 28, 3002, 15A, B, and C, all right? And the United States is foreign to the Union of States. This is why they formed a more perfect union in the several states, which is the state ofs, because they are subsidiaries of the United States. And again, the United States is nothing more than a glorified property management that has to prove minimal contact in order to have jurisdiction to extend their extraterritorial jurisdiction over you. They need you to be willfully incompetent and ignorant of what I am talking to you about. And this is how they ensnare people in their artifice and scheme, because people aren't learned enough to comprehend that the government was never created to lord over them, but rather to protect their life, liberty, pursuit of happiness, and enjoyment of property, which is exactly why they don't teach civics in school anymore. Body politic or corporation capable of being defrauded and affirmed the authority to prosecute such crimes under common law principles. Okay, so now we're pointing out the common law principles, all right? And common law is twofold. It can be dangerous on one side and quite pleasant on the other, but common law is typically the common occurrences of today. So the common law back in 1700s is definitely not what is common today. All right, so you got to be careful with this common law. You want to understand the jurisdiction that you're in. Remember that 1 Timothy section 9 says the law was written for the heathen, the man-stealer, the murderer, the thief, all right, the robber baron. That's the law of the Pharisees. That's Roman civil law. That's your statutes, codes, city ordinances, rules, and regulations that are written for people without moral compass or moral fibers that don't understand the difference between right and wrong, all right? So the law of the Pharisees was not written for you, all right? And so it's imperative to understand and comprehend who you are, and most importantly, what you are not. Chisholm versus Georgia, 2 U.S., 2 Dallas, 419, 1793, allowed citizens' suits against state. Now, they said this was overturned by the 11th Amendment, highlighting the federalism debates. However, under Monell, because they're operating as a private for-profit corporation, unjustly enriching their principal by ensnaring you in artifices and schemes through their legal system, okay, they don't have 11th Amendment immunity, all right? 11th Amendment immunity is a farce. And what do I mean by that? Well, ladies and gentlemen, anybody claiming that they have immunity, that presupposes that there are men and women above the law, all right? And nobody's above the law, not even myself. We operate by a law, in fact, the highest law on the land, the highest law in the universe, all right? And they're trying to get you to degrade your status and demote yourself to being subject to their legislative edicts, which would be considered bills of attainder, where you're guilty until you prove yourself innocent, not innocent until proven guilty. There is a clear difference, all right? Glass versus the Slope Betsy, 3 U.S., 3 Dallas, 6, 1794 established federal courts having what? The exclusive admiralty jurisdiction, ensuring what? Uniform maritime law. This is why in the Code of Federal Regulations, the United States Code and the oh, good gravy, why am I? Oh, the Federal Table of Authorities supersede any of the definitions that the state comes up with, because they're all subject in administering the bankruptcy to federal uniform laws, which means, for example, under the Motor Vehicle Safety Care Act or the Motor Vehicle Code or the Department of Transportation Code, all those definitions take precedent over anything the state has defined with their definitions. All right, and this is how you can prove that a motor vehicle is a commercial motor vehicle engaged in commercial activity. All right, remember that which is included excludes all others. Very important principle to know and understand. That which is included excludes all others. They didn't say that the Motor Vehicle Department of Transportation definition for motor vehicle includes a motor vehicle engaged in commercial activity and private leisure and pleasure as an automobile. There's a clear distinction and separation. Now, the state omits material facts when they, in every state, they describe what a motor vehicle is. They fail to disclose that a motor vehicle must meet the criteria of being engaged in commercial activity. Calder versus Bull, 3 U.S., 3 Dallas, 386, 1798, limited ex post facto clause to criminal laws, protecting against arbitrary retroactive legislation. In other words, they couldn't create a new law today and then charge you for that violation of that law when that law never existed and you engaged in that activity 5 years prior, okay? But it's also exhibited in Article 1, Section 10, which I think is funny in the Constitution. People really need to start reading the Constitution. No ex post facto laws, no bills of attainder. The government cannot impede the obligation of contract, okay? And these are all very, very important. So I use the Article 1 through Article 10, and the first 10 amendments is what I really use in standing on my square, having substance, all right? Because 1 through 10 are absolutely 100% valid, even up to the 13th Amendment. After that, it gets a little shaky, okay? And I'll explain that in a whole nother video. Marbury versus Madison, 5 U.S., 1 Cronch, 137, 1803, established judicial review. This is important. When the federal courts say, oh, we can't review the lower courts. Yes, you can. First of all, under federal preemption, anything dealing with maritime admiralty law, you have the exclusive jurisdiction over, all right? And everything they're doing is civil in its nature, because after 1933, 27 CFR 7211, all crimes are commercial. It's all been monetized, ladies and gentlemen. Okay, absent a victim, there is no crime, no corpus delicti, no malium inse, no malium prohibitum. With that being stated, it is a constructive trust. You're going to express the trust. You're going to let them know that you're the grantor, bailer, owner, beneficiary, and entitlement holder and heir to the securities generated. All right? So we can do a conditional acceptance. I'll accept your charges provided you can prove that you're the grantor, bailer, owner, beneficiary, and qualified heir to the rents, profits, proceeds, futures, and annuities from the claim security. And of course, they can't do it. So cut me my check and have a nice day. All right? Unconstitutional Law Foundation, Marbury versus Madison, 5 U.S., 1 Cronch, 137, 1803, established judicial review, enabling courts to strike down unconstitutional laws. In fact, this didn't even enable them to do so. It was their duty in the first place to strike down unconstitutional laws. Foundational for protecting individual rights. Bennett versus Boggs, 1 Ball W, 60 CCED, Pennsylvania, 1809, held statutes violating common rights are void. Not just voidable, they are void. from their inception, supporting challenge to arbitrary licensing. All right, because licensing deals with commercial, and what they're doing is manufacturing consent through a false, misleading, and deceptive trade practices, through a false conveyance of language to ensnare you in an artifice and a scheme to get minimal contact so they can hold you subject to statutes, code, city ordinances, rules, and regulations, which are tied to penal sums and penal bonds, so they can generate revenue. I call it taxation without representation, because the masses are ignorant, and they're allowing them to do this by way of presumption and assumption of a agreed upon contractual nexus. Mills versus DeRee, 11 U.S. 7 Cronch 481 1813 required full faith and credit for state court judgments, ensuring consistent enforcement across state and challenging void traffic tickets. Okay, so you can go and use other states' judgments under Article 4, Section 1, the full faith and credit clause, invoking those judgments in your favor. Delavive versus Boyett, 7F CAS 418 CCD, Massachusetts, 1815, defined broad federal admiralty jurisdiction to include maritime contracts. Okay? This is important for all those attorneys out there that are telling me that I don't know my ass from the hole in the ground. I don't know what I'm talking about, because there is no maritime admiralty jurisdiction. They're completely full of shit. Either they're inept and incompetent, or they're intentionally giving false and misleading and deceptive information out there to ensnare people in turmoil, to unjustly enrich their principal. Either they're dumber than a sack of shit, or they are intentionally deceiving you. All right? So, defined broad federal admiralty jurisdiction to include all maritime contracts, torts, and injuries, such as marine insurance policies, not limited by English title rule, expanding the scope beyond common law restrictions. All right? This is that expanded footprint, if you will, that extraterritorial jurisdiction. McCulloch versus Maryland, 17 U.S. 4 Wheat, 316, 1819, affirmed federal supremacy, voiding state laws conflicting with federal law. Ergo, Title 18 United States Code, subsection 31 for motor vehicle definition. Motor vehicle definition in Title 18 United States Code 31 clearly articulates that a motor vehicle is a motor vehicle engaged in commercial activity. That's why state law, when they just say a motor vehicle is anything propelled by gasoline, blah, 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 and they fail to mention that is engaged in commercial activity, you hold them accountable under Title 18, subsection 1331, that gives the full definition of what a motor vehicle actually is. Remember, words have power and words have meaning, and the law is specific. Affirmed Congress's implied power under the necessary and proper clause to establish a national bank, and held that states cannot tax federal instrumentalities, reinforcing federal supremacy over conflicting state actions. Trustee of Dartmouth College versus Woodward, 17 U.S. 518, 1819, determined that the private college charter is a contract. Remember, Article 1, Section 10, government can't impede the obligation of contract. All of you, ladies and gentlemen, are free to make conscious decisions of your own choice, okay? But remember, you can't waive your rights unless it's knowingly, willingly, and intentionally, meaning that full disclosure has to be had. Due process of law must be followed. You must be fully availed of all the legal consequences by signing and entering into the contract. And remember that a contract requires 2 signatures, okay? It requires a signature for one providing value, and it requires a signature from the one who is bound to provide the consideration. Determined that private college charter is a contract protected by the contract clause of the Constitution, preventing states from unilaterally altering or impairing such private corporate charters without consent. This is important. They always need your consent. They're manufacturing your consent. By the presence of the body waives the error in the name under the doctrine of idiom sonum. If it looks the same, it sounds the same, it is the same, and they're presuming and assuming under maritime admiralty that you are there of your own free will and volition. Never mind that they tell you that if you don't show up, they're going to issue a warrant, which isn't really a warrant. It's a capias, all right? We're only supposed to be in the courts under one condition, and that is that a grand jury indictment, a true bill, has been presented, okay? Other than that, for an infamous crime. Other than that, you're not supposed to be in their courts. Houston versus Moore, 18 U.S. 5 Wheat, 1, 1820, affirmed federal law supremacy under the Supremacy Clause, invalidating conflicting state laws, ergo licensing versus travel rights, upheld states' authority to enforce federal militia laws through its own court-martial for delinquencies, establishing concurrent jurisdiction where federal law does not preempt state actions in militia matters. Now, this is important too. We need to go look at the 9th Amendment, the enumerated laws and the unenumerated laws, ladies and gentlemen. And if we read the 10th Amendment a little more clear, it states that the laws, that the power is not delegated to the federal government, therefore reside in the state or to the people. It's the last 4 words that none of these idiots want to read. So it's imperative and incumbent upon you to read it in its entirety to understand that the state is we the people. It is us. Cohens versus Virginia, 19 U.S. 6 Wheat 264, 1821, upheld federal judicial review over state court decisions. Ladies and gentlemen, they keep telling you that they don't have the ability to review the decisions coming out of the family court. That should tell you immediately that it's a special star chambers venue operating outside the Constitution, operating outside the judiciary. It is a special star chambers venue where they're trying to get your consent and manufacture your consent and issue threats, duress, and coercion, engaging in RICO activity to get you to engage in a contract. All right, your silence being acquiescence. So you really have to stand on your shit and point out the fact that these people are operating outside the judiciary, masquerading around as judicial officials or officers of the United States, violating Title 18 United States Code 911. Upheld federal judicial review over state court decisions, reinforcing federal supremacy in constitutional disputes. This is why you're going to make everything a constitutional or diversity of citizenship issue under Title 28 United States Code 1331 or 1441. Confirm the Supreme Court appellate jurisdiction to review state court decisions in criminal cases involving federal questions, reinforcing federal judicial authority over state courts in matters of constitutional or federal law. All right? People versus Herkimer for COW 345 New York 1825 applied the agency principle that notice or knowledge given to an agent, such as a deputy sheriff, is imputed to the principal, the sheriff, establishing this rule in the context of a negligence indictment against a public official. In other words, the subordinate of the sheriff, if you give the deputy notice, okay, and the deputy doesn't give the sheriff notice to principal is notice to agent, all right? And the sheriff is still carries the primary active degree of fault for liability for what his underling failed to convey to him, as well as the deputy carries an unbridled amount of liability for failure to report up the chain of command, all right? So it's twofold. And this is where you hammer them on their Monell action, because the sheriff never properly trained his subordinate what to do in the event that reports were given to him and how they were supposed to transfer. This works for the clerk of the court. This works for the judges. This works for all government officials. To put one on notice is to put them all on notice, and they carry the primary active degree of fault to send it up the chain of command if it's above their pay grade. If they fail to do so, and the sheriff says, I never received it, guess who carries a primary active degree of fault? The deputy sheriff. But who carries an additional degree of fault and a primary degree of fault in a separate action? The sheriff, for failing to properly inform his deputies their duties and obligations. All right, so that's what grants rise to the Monell and a claim against the superior's bond. American Insurance Co. versus 356 bales of cotton, 26 U.S. 1 PET 511 and 1828 established federal admiralty jurisdiction supporting uniform application of federal law. American Insurance Co. versus Cantor, 26 U.S. 1 PET 511 1828 held territorial courts are legislative. All right, these are your Article 1, Section 8, Clause 9, private star chambers, military venues, okay, that are limiting your constitutional protections in territories. This brings up a great point here that needs to be made, is territorial jurisdiction. Where did it come from? How did it manifest into its existence? And what are they doing? And how are they subverting from it? Well, they're subverting from it because we are staying silent. We're not bringing it to their attention that under the Declaration of Independence, the Articles of Confederation, and the Northwest Ordinance being key here, one of the 4 organic laws next to the Constitution, is that it points out the territories. Remember, anything that they have control over must be ceded to or owned by the United States, ladies and gentlemen, okay? And so if they can't prove that you were in their territorial jurisdiction, then they can't prove they have standing. They can't prove they're in the proper venue. They can't prove they have territorial jurisdiction. They can't prove they have subject matter jurisdiction or in personam jurisdiction. So venue is very important, ladies and gentlemen. You have to go read the Northwest Ordinance to understand how these districts and territories apply and how they were created and where their authority is, and most importantly, where it is lacking. Federal territory courts are legislative courts created under Article 1 of the Constitution. That's Article 1, Section 8, Clause 9, lower inferior courts. This is where you have your administrative law judges, administrative law clerks, being ministerial administrators, presuming and assuming that there's a contract and that they're going to proceed in rem, dealing with things, all right, that belong to or ceded to the United States, or that you entered into some type of contractual agreement, but there is no evidence on the record that you have. It's a presumption and assumption, not Article 3 judicial courts, and thus do not require judges for life tenure or salary protection affirm that such courts can exercise admiralty jurisdiction over prize cases in territories. Again, this is how we can disqualify them under Title 28, United States Code 455, because if they all have to pay taxes, ladies and gentlemen, guess what? They're working on behalf of the principal, enforcing the principle. This is why I call it taxation without representation. They're working on behalf of the very principle that they pay taxes to and have an allegiance to that is outside Article 3, subjecting you to taxation without representation under the presumption and assumption that you are bound by state legislators or the federal legislators creating legislative edicts that are tied to penal bonds and penal sums as they administer a bankruptcy, and they're trying to make you the debtor when really you're the creditor. And that's found in the 73rd Congress, First Session, Volume 77, Part 1, 1,165 pages. Elliott versus Pearsall, 26 U.S. 1 PET, 328, 1828, declared that judgments from courts lacking jurisdiction are void. Not merely voidable, they are void, in abnitio, from their inception, ensuring due process and dismissal defective tickets, okay? And dismissing defective tickets. You are being denied due process of law. The officer on the side of the road can either be the agent for process of service or he's the witness. He cannot be the agent for process of service and the witness both simultaneously. So either the state properly served you or they have a witness. So either the state properly served you through its agent and agency being the officer and they don't have a witness, or they have a witness and you were denied due process of law. Once you're denied due process of law, if they even had jurisdiction, they just lost it, and it's not something that they can get back. It's all considered fruit from a poisonous tree under the fruit from poisonous tree doctrine. Ruled that a deed acknowledged taken by the county court without proper jurisdiction, specifically for a married woman's conveyance, and I'll get into this whole marriage thing a little bit later. We'll talk about that another day. Are you guys firmly aware that a marriage license is actually a patented construct under the United States Patent and Trademark Office, and it's between the man and the state and the woman and the state, and it's a patent, ladies and gentlemen, that's held at the United States Patent and Trademark Office. It has nothing to do with your Heavenly Father. It has nothing to do with wedlock and being with your wife, and it has everything to do with two people contracting with the state and the state being the beneficiary of the entire thing. It is invalid, and judgments or acts from courts lacking jurisdiction are void, emphasizing the necessity of jurisdictional authority for legal validity. All right, so there has to be a contract. You have to put them. The onus of probandi falls back on them to prove where the joinder occurred, ladies and gentlemen, and how they got joinder. They're going to presume and assume the minimal contact doctrine. They're going to ask if you have a driver's license. No, you do not have a driver's license. The estate has a driver's license, ladies and gentlemen. You don't have shit. Okay? Do you have a social security number? No. The estate has a social security number. You are merely the beneficiary and the entitlement holder, the heir to that. You have beneficial use of it. You don't own it. That's why the primary active degree of fault falls under Title 18, subsection 8. All obligations are obligations of the United States for what they did in 1933 under Proclamation 2039, Proclamation 2040, so on and so forth. What's up, Brother Keith? I say dumb as a sack of shit. Please elaborate, brother. Please elaborate. Let's go further in here. And so you can disqualify them under Title 28, 455 because they're fiduciaries and trustees, and they have a conflict of interest financially in the matter. Lansing versus Smith, 4 WEND 921 AM, December 89, New York, 1829, held a canal company liable for flooding caused by negligent construction, establishing a duty of care. See, you can operate on the freeways, highways, byways, and passages without a driver's license, all right? You have the right to travel in your private modern-day conveyance to and from as you see fit, all right? And all you have to do is exercise a duty of care because you're still liable. Just like the First Amendment, you have the freedom of speech and you can say whatever you want. It doesn't mean you're not liable for the things that come out of your mouth, all right? So we exercise a duty of care. That's the only thing incumbent upon you, all right? And then they say, well, what if you got in an accident? Okay, well, first of all, that's a hypothetical. And secondly, even if I got into an accident, it's civil unless you can prove that my intent was criminal in its nature. It's a civil matter. It has nothing to do with law enforcement, and it's civil. Determined that the state, as sovereign, inherits the prerogative rights formerly held by the king, allowing it to improve public navigation, such as constructing basins or canals without compensating adjacent property owners for incidental inconveniences or losses, as no private rights are violated. Now, this case, and this is what I love about this stuff, these cases can be overturned. So when they tell you that courts create the law and it's known as case precedent, res judicata or stare decisis, understand that it's not necessarily the law. It's just an opinion, and you can go challenge it through a direct attack or a collateral attack. You can find procedural violations why it can be overturned and thrown out. You can find constitutional violations why it can be overturned and thrown out. So case precedent, whether it be stare decisis or res judicata, doesn't necessarily mean it's law. It's just the opinion that carries weight at the time. All right? Johnson versus 21 Bales, 13 Fed case, 863 CCD, Virginia, 1829, in a prize case, which is Maritime Admiralty jurisdiction, from the War of 1812, which the War of 1812 was never ended by way of proclamation, held that a claimant's long-term residence in enemy territory with intent to remain establishes domicile. All right, this is how they're charging everybody up, by the way. An enemy charter or enemy character under prize law, overriding prior U.S. naturalization, making the property subject to capture and condemnation regardless of ignorance of the war or its location on an American vessel. Didn't I just tell you guys that all the birth certificates are American vessels, United States vessels? Didn't I tell you that the Social Security juristic person is a United States vessel? All right. So, again, this is why they're not giving you just compensation on the side of the road. They're just taking your property because you registered it with the United States, unwittingly and unknowingly waiving your rights. And now you are not in constructive possession of the actual deed. You have a certificate of title, which is color of title. All right? That's not to say that you can't overcome that by arguing through title, but most people don't. All right. And so before your property can be taken from you, there must be a pre-seizure hearing and a post-seizure hearing. But guess what? If you don't say anything, if you don't make an issue, you waive the issue. Where was my pre-seizure hearing? Where was my post-seizure hearing? And where was my just compensation for these assholes using my private intellectual property without my consent for the betterment of their principal? All right. I'm due and owing here. All right. Very important to understand a pre-seizure hearing and a post-seizure hearing. You were denied due process of law. Therefore, your rights are property, ladies and gentlemen. They have value, but they only have value if you yourself stand on them principles and stand up for your rights. Your rights are property and property are rights. Without one, you can't have the other, ladies and gentlemen. You have to know these things. They're not teaching this to you in school. Bennett versus Boggs, 1 Bald, 1830, declared a Pennsylvania statute imposing penalties on dams built in non-navigable streams without legislative approval to be void. Where's the enactment clause? Where was the enactment clause? They're going back and they're looking at it going, look, this is non-navigable waters. You can't just go around here and create state statutes that imposes the state's will on people's private property and take their property through eminent domain and stuff without having the actual legislative authority to do so, supported by the enactment clause, as it violated plain principles of common right and reason by interfering with private property rights. So again, Now we're talking about private property rights. Earlier we were talking about common right, natural rights. Now we're defining private property rights, affirming judicial authority to invalidate such laws. In other words, the federal government, through supremacy, is coming back and overturning a benign case that was deliberated, wherein the state courts decided to rob the people of their rights through the legislator, and the federal judiciary came back under the supremacy clause and said, bullshit. Craig versus Missouri, 29 U.S. 4 PET 410, 1830, held state definitions cannot override federal statutory terms. Held that state definitions cannot override federal statutory terms, ergo motor vehicle in 18 U.S.C. subsection 31, ensuring uniform federal law application. Ruled that Missouri's insurance of loan certificate, which functioned as currency backed by states' credit, ruled that Missouri's insurance of loan certificate, which functioned as currency backed by the state's credit. What is the state again? Oh, that's right. The state is we the people. All right. Go read the 10th Amendment again. Okay. Or by the people of the state, right? Constituted bills of credit prohibited by Article 1, Section 10 of the Constitution, invalidating the state law and reinforcing federal limits on state monetary powers. Parson versus Bedford, 28 U.S. 433, 1830, held that the federal district courts must, not might, not shall, must conform to state procedural rules and modes of proceeding in common law actions as mandated by the Judiciary Act of 1789 and Process Acts, affirming the district court's refusal to record verbal evidence in a manner not required by Louisiana practice. All right, so orally, under the Uniform Trust Act and the Uniform Trustee Act, you can express the trust orally. I believe that in the Uniform Trust Act, it's under Section 401 and 402. All right, but as far as going through their maritime admiralty bullshit, in the Judiciary Act of 1789, they commingled equity and statutory jurisdictions, all right, for their benefit, not for yours. Hoke versus Henderson, 15 NC 1, 1833, declared a state statute unconstitutional for attempting to divest a public officer of his position without due process. Due process is notice and opportunity, establishing that a public office held during good behavior being key, is a property right. This is why they can't take the driver's license from you absent a hearing, by the way, ladies and gentlemen, this case right here, okay? It's considered a property right. Even though it belongs to the state, you have a property right interest in it, protected from arbitrary legislative interference under principles of vested rights and substantive due process. There's another new one for you, substantive due process, okay, and vested rights. Jackson versus Ashton, 33 U.S. 8 PET 148, 1834, dismissed a case for lack of federal jurisdiction, restricting federal courts to diverse parties or federal questions. This is why you're rolling everything over from the state court into the federal jurisdiction, whether it's under preemptions or Title 28 United States Code 1331 or 1441, diversity of citizenship or federal questions. Dismissed the case for lack of federal jurisdiction due to incomplete allegations of diversity of citizenship, establishing the requirement for proper pleadings of parties' citizenship to invoke federal diversity, jurisdiction, and restricting federal courts to cases with diverse parties or federal questions. Again, you're always going to be a diverse party because you're foreign to the United States. You're foreign to them. Bank of Augusta versus Earl, 38 U.S. 13 PET 519, 1839, recognized corporations as citizens. There it is. Corporations as citizens for diversity jurisdictions supporting interstate operations under maritime admiralty. Held that corporations chartered in one state can conduct business and make contracts in another state under principles of committee, unless expressly prohibited by local law recognizing corporations as citizens of their chartering state for diversity jurisdiction and supporting interstate operations. This is where Citizens United, everybody needs to go read Citizens United. This is how these lobbyists and stuff and politicians are getting their pockets padded because corporations are considered citizens. And under the 14th Amendment, they have rights, all right? Spooner versus McConnell, 22F 939, CCD, Ohio, 1838, denied an injunction against state canal construction that might obstruct navigation, establishing the Northwest Ordinance. Oh, there it is, the third organic law, right? You know, you want to go back to the four organic laws, the Declaration of Independence, the Articles of Confederation, the Northwest Ordinance, and the Constitution. And right here in 1838, they're pointing out the territorial jurisdiction under the Northwest Ordinance provisions for free navigable waters remaining binding on states as a compact. They're going to call it a compact or agreement, not necessarily a contract. All right, but compact, agreement, and contract are all the same. But states can improve navigation without violation, and individual claims require proof of specific irreparable harm, affirmed federal retention of proprietary rights in navigable river beds, while states hold political jurisdictions subject to the compact, agreement, or contract. Warren versus Beers, 23 WEND 103 New York, 1840, held the constitutionality of New York general banking law of 1838 by ruling that banking associations formed under it are not corporations. This is important. This is important when you understand what Andrew Jackson did and why there are no banks in the United States. They're all non-member banks, affiliate banks, banking associates, but there are no banks in the United States. They all work on behalf of a foreign principal. Within the state's constitution, restrictions on special charters, but rather partnership or associations allowing general incorporations without legislative special acts. Pennsylvania Railroad Company versus Johnson, 7W and S, 317, Pennsylvania, 1844, held that the railroad company is liable for damages caused by negligence in the construction or maintenance of its tracks, establishing corporate responsibility for torts committed by its agents. This is why the 11th Amendment immunity doesn't apply, because they're all operating on behalf of a corporate principal to unjustly enrich themselves under the guise that they operate and are acting as government officials in the course of business, reinforcing principles of common courier liability. Smith versus Tucson, 48 U.S. 7 Howe, 283, 1849. Citizens of the United States have the right to pass and repass through every part of the country without interruption as freely as in their own states. This is the reason I'm quoting this is equal protection of the law. Okay, if citizens of the United States have a right to pass and repass, egress and regress and ingress as they see fit without interruption, you have that same right too. Passenger case 48 U.S. 7 Howe, 283, 1849, affirmed the right to free interstate transit as a core citizenship attribute protected from state restrictions. In other words, they can't lay a fee or a fine on you, convert your right into a privilege in order for you to go from point A to point B as you see fit at your leisure and your pleasure. Luther versus Borden, 48 U.S. 7 Howe, 1, 1849, held disputes over state governmental legitimacy are non-judicial, judicable. They are political questions deferring to Congress. So you need to put the Congress on notice that you know what's going on. They carry the primary active degree of fault, that it's a trust, that they're responsible for offsetting and discharging any incurred liability that you may have been presumed and assumed to have, because under Title 18, subsection 8, all obligations are obligations of the United States, and under the 73rd Congress, First Session, Volume 77, Part 1, we are, in fact, recognized by Congress and the House of Representatives assembled as the creditors, and therefore they are the liable party for all notes, drafts, bills of exchange, bankers' acceptance, trade acceptances that we create, which create new money that is then lent to the bank, that the bank then takes to the comptroller of the currency, verifies, and has the Treasury, the Secretary of Treasury, issue Federal Reserve notes that are for bank-to-bank transfers and no other purposes are hereby authorized. Establishing the political question doctrine, holding that disputes over the legitimacy of state governments under the Republican form of government for which we were guarantee clause, are non-justicable and must be resolved by the political branches, particularly Congress, rather than the judiciary. And this is where you're putting Congress on notice of their liability and the duty that they owe you to protect your unalienable rights to life, liberty, pursuit of happiness, and the enjoyment of property under the construct they created so they could float their form of government. Smith versus Turner, 48 U.S. 283, 1849, invalidated state statutes imposing taxes on alien passengers arriving in ports, ruling them unconstitutional as they interfered with federal authority over commerce and immigration. The decisions also affirmed the right of citizens to travel freely across state lines without undue interference. State versus Couture, 23 VT 1454 AM, December 90, 1849, the common right of the jury to determine both the law and the facts remains unimpaired. In other words, when they're giving you a jury trial, they're denying you the Seventh Amendment, which is your right to trial by jury, where the jury decides the law and the facts. So what they're doing is they're taking you into Special Star Chambers venue under maritime admiralty jurisdiction under the presumption and guise that you are engaged in minimal contact with their association or principal, and therefore subject to it. And they're going to give you an administrative law clerk, an administrative law judge, a ministerial administrator, and they're going to rule against you in the favor of their principal, because all of these corporations are in fact contracted with the states and Washington, D.C. for enforcement of their rules, regulations, policies, and procedures. And that's what they're doing, ladies and gentlemen. They're holding you accountable to these corporations because there's a presumption and assumption that you've entered into contract, and therefore you're liable for procedure and policy violations under these businesses. Affirmed the common law right of juries in criminal cases to determine both the law and the facts, reversing a conviction where the trial judge improperly instructed the jury that it was bound by the court's interpretation of law. I have been through a number of trials now, some of which I've been involved in, others that I haven't. I just sat there and watched, and it never fails. They will always say from the bench, "Now, jury, I will instruct you of the law as the judge. It is my duty and obligation to instruct you of the law, and you will decide whether or not the state has met its burden by the evidence that it produces, and whether or not the state has, in fact, produced any evidence that is factual in its nature, and you can rule on whether or not the state has proven beyond a reasonable doubt and established the facts, and I will tell you the law that you're going to abide by." That's tampering with the jury, ladies and gentlemen. That's a violation of their oath of office. That's mixed war against the Constitution. That's denial of due process of law. That's a void judgment. You can motion to set aside, you can motion to quash the judgment, or you can vacate the judgment. You can do a collateral attack on the judgment. You can do a direct attack on the judgment. You can go after it for being a void judgment. All right, and you can get paid for that. Piper versus Pearson, 2 Gray, 120, Massachusetts, 1854, held that judicial officers such as justice of the peace are not immune from civil liability. Well, there goes your 11th Amendment immunity right there. All right, they're not immune from civil liability. All right, when they act without jurisdiction, as in committing a witness for contempt in a case over which they had no authority, treating such action as those of a private citizen. In other words, they're personally liable in their personal capacity for causing you harm, damage, loss, and hardship, and their wives are accessories after the fact because they're unjustly enriching themselves while violating the law, engaging in mixed war against the Constitution by extorting you, by trafficking your person, by engaging in human trafficking, by issuing threats, by colluding and conspiring against you. All right, they're liable in their personal capacity. And again, I would encourage you guys to go check what I'm talking to you about. I'm not without my flaws and defects, but I would strongly urge you guys, there's no substitution for reading. I would strongly urge you guys to go check this stuff out and really comprehend it and understand it. Absent a victim, there is no crime. So if they're alleging that it's a criminal action, right away you know that you're being denied the Sixth Amendment. There's no verified criminal complaint sworn to under the pains and penalties of perjury, independently bonded. Therefore, this is a constructive trust, and you're going to come forward as the grantor, bailer, owner, beneficiary, entitlement holder, and qualified heir to the complaint security, and you want a full accounting under UCC 9-210. They brought fraud on the court. They have no standing. They have no jurisdiction. They don't have territorial jurisdiction, subject matter jurisdiction, in personam jurisdiction. They don't have extraterritorial jurisdiction. That's a farce, all right? And if they want to give you any lip about it, you could tell them that if you wanted any lip from them, you'd peel it from your zipper, and that's a polite way of calling them a cocksucker. All right? And you tell them right away that you're going to hold them accountable. You're going to file the proper forms and give the proper notifications to the SEC, to FinCEN, the 101, 104 form, the 114 form through the SEC, that you're going to notify the IRS with your 4506A, 13909, 3949A, and 211 form, that you're also going to inform the Secret Service and the Department of Justice of the securities fraud. And again, this qui tam criminal charges were approved and ordered in the U.S. tax court, filed against the clerk of the court, the judge, the DA, and the deputy prosecutor who willfully embezzled the case trust securities after the grantor, bailer, owner, beneficiary, entitlement holder, qualified heir, and secured party revoked and revested the securities and filed the UCC1 liens, IRS paperwork, and securities not only for set off and discharge of the commercial liabilities, but arrested and attached the bar members' bonds to pay the taxes due, ladies and gentlemen. And this is currently going on right now. And again, they don't have their Title V United States Code 3331, 3332, 3333. They don't have the SF-28. They don't have the Form 56 on file. They don't have the Social Security Administration 98 on record and filed. They don't have a delegation of authority from the Solicitor General from Washington, D.C. They don't have the Title 26, 2032 AE11 bond that covers the taxes on record and on file. And so you're going to report on the SF-28 to the Inspector General of the GSA and let them know that they're operating without authority and they're engaged in embezzlement, racketeering, extortion, tax evasion, money laundering, and you don't want to be any part of that, all right? So it's important to do all that. Anyway, I've been on here for a little bit. I was just helping you guys out. Hope this helps you out. I have no idea how long Facebook will leave this up. They say 30 days, but in most instances, when I start dumping information like this, they do away with the information. They delete it or say that there was a problem uploading it or I lost service or whatever the complication is that they wish to extend. We do have a class coming up really soon to teach you guys how to navigate this stuff and how to terminate, revocate, do a rescission on all contracts, and to hold them accountable by giving them a notice of liability that if they continue to maintain a record in error after you've given them notice, they carry the primary active degree of fault to the tune of $1 million per agent, per occurrence, per time that you're violated and your rights are violated after you've duly given them notice that they're maintaining a record in error and that you no longer wish to voluntarily comply with their legislative edicts and bullshit because it's not mutually beneficial for all parties involved. And again, a contract requires 2 signatures. So if it's a unilateral contract, you can terminate it at any time. And you can also tell them that that's your intellectual property that they're in constructive possession of, and they're maintaining the record in error that's causing you harm, damage, loss, and hardship. And by notifying them of that, if they don't correct the record or remove your private intellectual property from their records, that you're going to invoice them for every day that they maintain those records and every instance that you are caused harm, damage, loss, by the record and error that they're maintaining after giving them notice. Very important stuff. How many cases can you put on one form? I'm not sure what that means, but I have over 500 cases here listed. Let's see. Let's go all the way through them. Of course, they're not all numbered, but I have over 540 cases that are here. And I started with the oldest ones, working my way to the present time so I could kind of show people how it slowly became manipulated and slowly got structured. I feel it's best to always go as far back as you can to the present to give it context and structure. So anyway, with that being said, I was given this information, disseminating this information the other day, and TikTok banned me until the 14th. And I always think it's funny when they ban me from sharing this information. And another code that I would like you guys to all go look at is Title 28 United States Code 1359. Title 28 United States Code 1359. Very important. And with that, I'm going to take a little break. I've been on here for a couple hours or whatever. I love you guys. Thanks for all your support, love, prayers, donations, contributions, information that you send me day in and day out. Understand that none of this is possible without the Heavenly Father. All the glory goes to the Heavenly Father. Everybody was called. Few will ever answer the call. Remember that. You have been called to be about his good works. You have been called, and it's whether or not you choose to answer that calling. And answering that calling can be as simple as sharing this live with other people. All right. It doesn't mean that you have to be out there on the front lines. Your calling could be simply taking this message and broadcasting it to others so they can ascend to the mind. Remember, all we can do is plant seeds. All we can do is be about the Heavenly Father's good works to help people ascend to the mind, to make a better today instead of hoping for a better tomorrow. We share this intellectual information and property, and we express that, we don't know everything there is. We're not perfect in all our ways. We ask that you exercise discretion and discernment and comprehend there's no substitution for reading. All we can do is give you information and allow you to ascend to the mind and water that seed and let it grow. You got to think outside the box, ladies and gentlemen. You were never meant for the confines and construct that they created to make you subservient to men and alleged governments. All right. You are free. Free meaning free from the legal constraints of another, absent a contract. That's what freedom is. All right. Free means you're free from the legal confines and constraints of a contract. Absent a contract, absent a victim, you have no duty or obligation. You are only bound by natural law and nature's God. All right. And it's important to understand that, ladies and gentlemen. So again, I thank you for all your prayers. I thank you for all the time that you spend commenting, although I don't read every comment and I don't read every private message I get. I do catch a few here and there when the good Lord directs me to them. And there are a lot of people that make very valid points out there, and to each his own. This is a individual thing. This is a spiritual ascension, but it's also a group effort as well. We are duty bound to make an observation, create a record, and report it. We are duty bound. That means that it's not malicious in its nature what we're doing. What we're doing is for the greater good of mankind throughout the world. Okay, it's not just about the United States or America. People go, oh, you're in America. Which America? There's North America, South America, Central America. Which America? All right. We are men and women who have been granted dominion. We are stewards and caretakers of what has been created, and we are not subservient to the constructs man created. In fact, it's the opposite. The constructs that man created are subservient to man, just like we are subservient to the Heavenly Father. So with that, I love you guys. Thank you so much for your support throughout the years. And I just wanted to bequeath and bestow upon you some very good information and hope to trigger free exercise of thought. So take this for what it's worth. I'm not perfect. I'm not free from sin. I'm no better than the rest of you. But I ask you to exercise cognitive thought process and think outside the box. Instead of following what you're told to do, start asking who, what, where, when, how, and why. And if they can't answer those questions, ladies and gentlemen, you're on the right path.